Good afternoon. Hello, everyone, and welcome to today's webinar, M&A Shareholder Litigation and Bump Up Claims. My name is Taja West, and I will be your moderator. I work on the marketing team here at White & Williams, and I'm excited to be hosting this session today. At this time, I would like to introduce our speakers, David Creagan and Justin Fortescue. David Creagan focuses on the efficient resolution of complex commercial disputes through negotiation, mediation, arbitration, and court litigation. Keeping their business strategies and fundamental values in mind, David works collaboratively with clients to understand their business and advance their interests through effective and nuanced legal approaches. David has represented public companies and their directors and officers in class action securities and merger-related litigation, and has also represented D&O insurers in coverage actions in state and federal courts. Justin Fortescue focuses his practice on insurance, reinsurance, and commercial litigation matters both in arbitration and in federal and state court. Justin prides himself on his ability to think outside the box and to provide clients with simple solutions to complex problems and issues. David and Justin have both represented public companies and their directors and officers in class action securities and merger-related litigation, and have also represented D&O insurers in coverage actions and in state and federal courts. Before I hand the mic over to our speakers, I have a few housekeeping items to cover about this presentation. First, in order to be eligible for CLE credit, you will need to record a CLE code that will be announced throughout the session. Please record this code. You will receive the required CLE forms after the presentation via email, where you will list the code. As a reminder, we love to hear from you during today's presentation. If you have a question for our speakers, please feel free to send it through the Q&A tab in the box to the right of our presentation. We'll be answering questions at the end of the presentation. If we don't get to your question during today's webinar, we will be sure to follow up afterward. With that, over to you, David.
Thank you, Tasha. As the next slide shows, this is our general disclaimer slide. Justin and I, in today's session, will not be taking a position on the issues that we're going to be discussing. Obviously, we have our views, but we are consciously not advocating one position over another. Policyholders and insurance companies, shareholders and directors and officers of corporations oftentimes don't see the same thing the same way. And as I say, we're just going to try to present to you the different ways of seeing some of the facts or hypothetical facts we'll be discussing without taking a position of our own on those facts. This presentation will essentially be divided into two parts. In the first part, I'm going to discuss mergers and acquisition litigation and the kind of essential background that we all know, we all need to keep in mind when thinking about mergers and acquisitions and the litigation that can follow from mergers and acquisitions. And in the second part of the session, Justin will more specifically talk about a kind of claim that oftentimes does come out of a merger and acquisition litigation, namely a bump-up claim. Some of you may know what a bump-up claim is, some of you may not. We're going to keep you in suspense a little while longer, and we'll describe what that kind of a claim is later on in the session. First slide, please. So by way of background, but really essential background, we need to talk about the fiduciary duties that directors and officers of a corporation owe to the corporation and to the corporation shareholders. Now, when I say corporation, generally speaking, and this is going to be true throughout the session today, we're talking about publicly traded companies. And in the sort of merger and acquisition litigation that we'll be talking about, at least one of the parties to the merger or the acquisition is going to be a publicly traded company. So in the context of a merger or an acquisition, the first duty that directors and officers owe to the shareholders is the duty of care. I'm sure you've all heard about that. And what it means in the corporate context and what it means in the context of a merger or an acquisition is the ordinary prudence and diligence that a director or a senior officer of a corporation should bring under the circumstances. So when you're talking about a sale or a merger for that matter, there are a lot of things to think about. You've got to think about what kind of a sale is it going to be? Is it going to be for cash, or is it going to be a share for share exchange? Is it going to be a mix of the two? How is the sale or the merger going to be conducted? What sort of due diligence is going to be done about the merger or acquisition partner? Realistically speaking, unless a senior officer or a director or the board of directors as a whole is grossly negligent in considering those things, or even reckless, generally speaking, they will get a pass from the courts, perhaps not a complete pass, but oftentimes, again, except in more extreme circumstances, the duty of care itself will not be at issue. However, there's a second duty that directors and officers owe to a corporation that oftentimes is at issue in mergers and acquisitions, and that is the duty of loyalty. And what that essentially means is a director or a senior officer of a corporation cannot engage in any sort of self-dealing really at any time when you're talking about any sort of corporate opportunity. But today we're talking about mergers and acquisitions. And in that context, in that setting, the officers and directors have to always put the interests of the corporation and its shareholders first, regardless of what their personal interests might be with respect to a transaction or with respect to a particular bidder for their company, if they're the D's and O's of a target company. The interests of the shareholders have got to come first. And by the way, I should probably also add that when we're talking about mergers and acquisitions and the litigation that oftentimes flows from a merger or an acquisition, and then subsequent bump claims and coverage litigation that ensue, most of the time we're talking about the target company, the company that is going to be acquired, or kind of the merger target, so to speak. So in that sort of situation, the directors and officers have to be careful to ensure that they've considered all the possibilities, even the possibility that the corporation shouldn't be acquired at all. Maybe it's not the right time, but if it is going to be acquired, got to get the best possible terms, which usually means money for the shareholders, and they've got to push their own personal interests in concluding the transaction or any transaction down to the bottom. There are certain standards of review, and I have Delaware in parentheses here on the slide deck because Delaware law, for obvious reasons, is really key when you're talking about mergers and acquisitions and about the sort of litigation and disputes that can arise from mergers and acquisitions. And there are basically three standards of review under Delaware law, which, as I say, is either going to be controlling or very, very persuasive if the litigation is in a different forum. The first is the business judgment rule. When I spoke earlier about corporations or directors and officers getting a pass on the duty of care, really I was kind of thinking of the business judgment rule, which is, let's call it the normal standard of review, the lowest standard of review, under which courts try to refrain from second guessing directors and officers. Courts are going to presume that the Ds and Os are acting in good faith, exercising their duties of loyalty and due care. And they're not going, even though a court could conceivably disagree with the decision that the directors and officers made, courts aren't going to second guess them. At the other extreme, we have the entire fairness standard. And that comes into play when a plaintiff, let's say, who's challenging the action of Ds and Os, in this case, a merger or an acquisition, shows that there were actual conflicts of interest on the board. And those conflicts of interest can take many forms, as we'll see shortly. The middle level of scrutiny, which sometimes called Revlon scrutiny or Revlon factors, in the M&A setting, Delaware courts will usually employ that enhanced middle level of scrutiny as a rule, really, because in the merger and acquisition context, courts believe with justification that there are many, many reasons why directors and officers could be conflicted or have personal interests that could conflict with the interests of the shareholders. Not saying they do conflict, but could potentially conflict with the interests of the shareholders in a sale or a merger. So when we're talking about mergers and acquisitions, as we are today, courts will employ this middle level of scrutiny, which they call enhanced scrutiny, or as I said, sometimes Revlon scrutiny. Next slide, please. We mentioned the duty of care and the duty of loyalty. So concretely, where the rubber meets the road, what does that mean in a merger and acquisition? In general, it means that the directors and officers have to exercise their duty of care and their duty of loyalty by getting the best price they can possibly get, reasonably get, for their company stock. And again, I'm talking about the Ds and Os of the target company. The Ds and Os of the company that's doing the acquisition, they're in a different position, obviously. I guess their shareholders could complain if they paid too much for a target. But certainly the target company shareholders are going to want to get as much as they possibly can get for their shares. How do you determine what the best price is? Oftentimes, Ds and Os can and really should get a fairness opinion or more than one fairness opinion from investment bankers and other professionals who can evaluate the value of the company in the transaction. There are different ways of doing it. There's a so-called intrinsic value, which is based upon discounted projected cash flows of the existing corporation as a going concern. There's a fair market value approach, which takes as its departure point, at least, the price at which the stock is trading on the market at the time prior to the, or maybe an average price over the last 3 months, 6 months, whatever, prior to the transaction. So there are different ways to do it. There are different methodologies. There are different things to consider, but certainly Ds and Os exercising their duties of due care and loyalty really should be going out and getting professional evaluations of the company's value. Next slide, please. And as I said, what that means concretely is an effort to get the maximum price that's reasonably obtainable for the target company. Next slide. The process behind the merger and the acquisition is really key and is the source of many challenges in litigation that ensues after or sometimes during a merger or an acquisition. The process should be competitive, arm's length, open, and fully disclosed. Again, going back to the duties of care and loyalty, this is to ensure that the directors and the officers really are out there, not putting the company up for auction, but nevertheless seeking multiple bids, just as you would if you were having an addition put on your house or something like that. You want to make sure you get the best deal and the best price. And the Ds and Os have a duty to make a full disclosure of all of that to the shareholders. In other words, we mentioned in the previous slide about getting a fairness opinion. That's the results of those opinions have to be fully disclosed to the shareholders. And really the entire process. What did the Ds and Os go through to ensure they were getting the best possible price for the company? Next slide. Oftentimes, as I said, the deal process itself will be challenged by shareholders, sometimes before closing, oftentimes after closing. And one of the things that shareholder plaintiffs will claim, of course, is that the sale process was flawed because it was insufficiently competitive. The Ds and Os of the target company did not try hard enough to get competing bids for the company, and therefore to ensure that they were getting the best reasonably attainable price, and or that the process was actually slanted toward one particular buyer. And why would that happen? Well, we come back to the conflicts of interest and self-dealing we talked about earlier. Directors and officers in the merger and acquisition context have a lot of things to think about. This is why the court will impose this intermediate level of enhanced scrutiny on M&A transactions when looking at the actions of the directors and officers. For example, senior officers, the CEO, the CFO, et cetera, may be concerned about their employment post-merger or post-acquisition. So if there are multiple bidders for a company, but one bidder has, let's say, promised them or at least held out the possibility of continued employment with the new company, and other bidders haven't done that, that obviously could conceivably taint the directors and officers' consideration of the various bidders. And it really shouldn't, because that's just their self-interest. They ought to be thinking only about the interest of the shareholders, i.e. getting the best price. Similarly, you have a situation with change of control payments to executives, where any transaction may result in a change of control. So I guess you could say the directors and officers in that situation, if they're entitled to change of control payments and they're looking at a sale or a merger, they want some sale to occur or some merger to occur. But here again, they also might favor one bidder over another because perhaps they're more favorable terms. Next slide, please. As I said before, the Ds and Os have a separate duty to disclose, and to disclose accurately and fairly everything that went on with their due diligence and their consideration of the sale and or merger. So for example, plaintiff shareholders will say, well, yes, you made disclosures to the shareholders, who after all have to vote on whether to accept the transaction. But maybe the financial advisors or the other considerations that went to the valuation were not fully or fairly disclosed to the shareholders. Now, that doesn't mean that every single last detail has got to be shared with the shareholders, but a fair summary, which is a term that's often used, is required. So the shareholders have to be able to understand what factors the directors and officers looked at, what their considerations were, how the company was valued, the different methodologies, the different factors that were taken into account. And the sale process itself, of course, can be misrepresented. As I said, it could be slanted toward one buyer without a corporate purpose. In other words, there could be situations, obviously, in which it's better for the company, better for the shareholders to accept an offer from one buyer over another, especially if that one buyer is offering more money. But if it's slanted towards one buyer over another for these private reasons that I mentioned, such as changing control payments or continued employment after the transaction, that's impermissible. And generally speaking, if that did happen, that won't be disclosed to shareholders, and shareholders have a right to complain about that. There was a very recent case decided in Delaware just earlier this year in Columbia Pipeline. The court's decision was on a motion to dismiss, but was nevertheless 120 pages long, and actually provides a very lengthy history of. There was a lot of litigation, by the way, leading up to this motion to dismiss. There were 3 or 4 different lawsuits brought, most of which, by and large, had been dismissed, culminating in this one class action. It's almost like this decision is almost like a law review article discussing all the various standards of review, the duties of disclosure, the duties of care and loyalty, kind of the history of litigation regarding mergers and acquisitions in Delaware. I mean, it's really a very comprehensive opinion. What happened here was that the CEO and the CFO were both counting on retiring following the transaction, and they were highly interested in the change in control payments and some other things, which led them to favor one bidder over another, none of which was disclosed to the shareholders and wasn't even disclosed to the other members of the board of directors. And the court described this quite accurately, I think, as fraud on the board, because you had the CEO and the CFO who were really running the sale process, withholding material information, really material information from the board. And in a situation like that, the board itself, not just the shareholders, doesn't have all of the information. It's interesting too, in this case, that the court found, again, this is at the motion to dismiss stage, so we're only talking under Delaware standards, reasonable feasibility of a reasonably feasible outcome from the allegations. But they found that the company that was acquiring Columbia Pipeline Group was also potentially liable for aiding and abetting the fraud on the board. That's a very difficult threshold to meet. It requires scienter. In other words, you have to have knowing participation on the part of the acquiring company in the fraud perpetrated on the board or on the shareholders by the directors and officers of the target company. Very difficult to do. A lot of plaintiffs allege that, very few are able to make it stick. Lastly, with respect to the Columbia Pipeline case, I just want to mention one thing. When you're talking about breaches of the duty of care or even the duty of loyalty, if in a post-closing damages action, the court finds that the vote of a majority of the disinterested shareholders of the company was fully informed. In other words, everything that happened, everything material that happened was disclosed to the shareholders, then that can actually cleanse the breaches of fiduciary duty. But in a case where the disclosure itself is flawed, in other words, the shareholders are not told about what the CEO and the CFO were up to, no cleansing of those fiduciary duty breaches is possible. Next slide, please. Oftentimes, plaintiff shareholders will complain about preclusive deal protections that discourage better offers. This goes back to slanting the transaction towards one bidder. no shop agreements. So you enter the target enters into an agreement with one of the bidders, agreeing that they won't go out, look for competing bids. Very high breakup fees, which make it very onerous for the target company to merge with somebody else or to be acquired by somebody else, and a right to match other offers. So if you might say to one bidder, look, if we get a better offer, you've got 4 days to match it. And only one bidder is given that right. Shareholders will complain about that because, again, they improperly will slant the deal to one bidder, perhaps without a corporate purpose. Next slide, please. We finally get to bump up challenges. So a little bit about bump up claims now. Justin will go into it in greater detail. What that essentially means is, as I said before, the Ds and Os are obligated to try to get the best price possible. They don't. The allegation from the shareholders is that the target company was sold on the cheap. The Ds and Os didn't get enough money for the target shares. Or I guess another way of putting it, especially if you're talking about potential aiding and abetting liability, the buyer didn't pay enough for the shares. It all amounts to the same thing, i.e. So-called inadequate or unfair consideration for the shareholders. So for example, easy example of a bump up claim, let's say a company is purchased or there's a merger, share for share exchange, and the shareholders get $11 for their shares. And the allegation is that the company was undervalued, should have been $12. So each shareholder then has been cheated, you might say, of $1. And then the question becomes, well, that the cheating was a result of breaches of fiduciary duties on the part of the directors and officers of the target company. But how are we going to measure the damages due to shareholders for those breaches? Well, we're going to look at how much they actually got for their shares versus how much they should have gotten, in air quotes. And that will be the measure of damages. And that really amounts to the bump up for the so-called inadequate or unfair consideration the shareholders got. Next slide, please. M&A litigation, down but not out. Almost for a while there in the mid 20 teens, almost every single deal involving every single merger and acquisition involving a publicly traded company was challenged in court, mostly in Delaware, but also in other states. Next slide, or next point, please. By the end of the decade, the percentage had gone down, but not much. And in the last couple of years, in 2019 and 2020, even with the COVID pandemic, and even though deal volume is down in North America, at least, and actually globally, M&A court challenges continue. Next slide, please. As I said, the venues have changed somewhat over the years since the In re Trulia decision in Delaware in 2016, which rejected very broad releases, class-wide, non-adversarial settlements involving non-material disclosures, additional disclosures to shareholders. Delaware hasn't been as favored a venue as it used to be. In re Trulia, by the way, is another one of those decisions. It's 60, 70 pages. Kind of gives you the whole history of disclosure only settlements. And again, what the court didn't like, a broad release of plaintiff's claims on a class-wide basis in a non-adversarial process, essentially, where the defendant DNOs agree with the shareholders that additional disclosures should be made, and the additional disclosures are really non-material. They don't add anything to the shareholders' knowledge of the transaction. Next point. In federal courts, as a result, the number of M&A class action cases has gone up, including Section 14 Exchange Act cases, which are a lot like the disclosure only settlement cases that are criticized so heavily in Trulia. There, however, the mootness fee settlements are narrower because they're not on a class-wide basis, and they don't involve these very broad releases of all claims. So courts look more kindly on the mootness fee settlements than they do on the disclosure-only settlements, which result essentially in attorney's fees and no real benefit to the shareholders. Next slide. Different types of M&A actions. There are appraisal proceedings where the shareholders ask the court to determine the fair market value of the company. Next bullet. Derivative suits where shareholders bring a suit on behalf of the corporation to recoup damages from the breaches of fiduciary duty of the officers. And lastly, there are direct actions by shareholders against the directors and officers seeking more money for themselves. I don't mean to say that in a cynical way, but seeking relief for the shareholders themselves for fiduciary duty breaches and sometimes violations of the securities law as well. And as I said, oftentimes that relief is expressed in the form of bump up damages. Next slide. Possible remedies: pre-closing, injunctive relief. You can stop the transaction. You can get additional disclosures. As I mentioned, they better be material if they're going to be worth anything to the shareholder and therefore get approval from the court. You also can change the terms of the deal, probably pretty rare. And finally, you can, of course, assess attorney's fees, which, without passing any judgment, is what a lot of this litigation comes down to. Next slide, please. Post-closing money damages, and we've already talked about this a little bit. You've got your alleged breaches of the duty of loyalty. You're going to have to essentially have gross negligence or even recklessness as far as breach of the duty of care goes in order to get damages. Negligence probably won't do it. And as I say, those damages are ostensibly oftentimes when the case is resolved either through mediation and or settlement, those damages are superficially unrelated to the number or the value of the outstanding shares of the company. But as you'll see, or as I've said, they are in fact related to the value of the shares. That's how the damages are calculated. And of course, attorney's fees are included there as well. Next slide, please. Finally, bump up damages. As we discussed, additional consideration for the shareholders of the target company, what they should have gotten for their shares as opposed to what they did get, and measured by the number of shares held and the price per share at closing. So if you had 100 shares, the recovery would be allocated pro rata for those 100 shares. Next slide, please. And now the all-important CLE code, 27 share 21. I'll repeat that. It's 27 share 21. You've got to include that on your form if you want to get credit for this CLE. Next slide. Bump up claims, how they work themselves out. The underlying shareholder action settles, oftentimes following a mediation. Next, the target company or the new company pays a settlement amount. We talked about that already. The difference between what the shareholders actually receive for the shares and the fair or real price, allocated pro rata. And finally, the insureds, which are going to be the target company and its directors and officers, of course, will then submit a coverage claim to their D&O insurers, asking to be reimbursed for this payment that was made to settle the shareholder action. And now at this point, I'm going to turn it over to my colleague, Justin, to discuss how these bump up claims are handled in the coverage context. Justin?
Thanks, David. Could go to the next slide, Taja. So really the first question we need to answer is, are bump up claims covered under a D&O policy? As David mentioned, at its core, a bump up claim is based on a payment that is made to shareholders to put them in the position they should have been had a sufficient price been paid for the stock in the first place. And so is that an insurable capital loss under a D&O policy? Not surprisingly, reasonable minds can and will disagree, but there may be at least a few reasons why the answer could be no. These claims are not covered. You could go to the next slide. So first is public policy. If you think about it, an argument can certainly be made that it's not a good idea to foist responsibility on insurance companies to cover these types of claims. Directors and officers may be incentivized to just take a deal, knowing that if, or more likely when, a lawsuit arises, their D&O insurance carrier will take care of it. And so is that really the purpose of D&O insurance? So rather than putting this responsibility on carriers, should it instead be the company's management that is responsible for getting a fair price when management makes the decision to sell the company? And I think you can certainly see the potential moral hazards that can arise when directors and officers are negotiating a deal if they think or even know that insurance will cover any shortfall in the amount paid or received. Go to the next slide. So another potential argument that bump up claims are not covered is that the payment of an amount that should have been paid to shareholders in the first place is not a loss under a D&O policy. And notably, at least one court has held this to be the case. Next slide. So that case was called Level 3 Communications versus Federal Insurance Company. It's out of the Seventh Circuit in 2001. And there, the underlying plaintiffs alleged that Level 3 had made fraudulent misrepresentations about the value of the shareholders to be acquired stock, which allowed Level 3 to buy the stock at an undervalued price. So in effect, Level 3 was accused of having obtained the plaintiff's company by false pretenses, and the plaintiff sought to rescind the transaction and recover their shares, or at least the monetary value of their shares. Well, Level 3 settled the lawsuits for $11.8 million, and it then sought to recover that amount from its D&O insurers. And the D&O insurers argued, among other things, that the $11.8 million was not loss, but was really restitutionary in character, since it represented the amount that Level 3 should have paid to shareholders in the first place. Go to the next slide. And here the court actually agreed, and it had a pretty good quote, I thought. So it found that an insured incurs no loss within the meaning of the insurance contract by being compelled to return property that it had stolen, even if a more polite word than stolen is used to characterize the claim for the property's return. And so this can be a potential argument with respect to any bump up claim, even if a D&O policy at issue doesn't have a bump up exclusion or a carve back from loss. There could be an argument that the claim is not covered. Of course, this argument has been rejected by other courts. So there are some other important things we need to look at when you're dealing with a bump up claim. Next slide. So maybe not surprising, the most important thing is the specific policy language at issue. And we're going to look at a few different examples of language and some courts that have interpreted it. And we'll see how small nuances in the language can really lead to creative arguments and potentially different results. Next bullet. Next thing to consider is extrinsic evidence. In most jurisdictions, a court is only going to resort to extrinsic evidence if the policy language is found to be ambiguous, that is, susceptible to more than one reasonable interpretation. And we'll discuss this in a bit more detail later. But extrinsic evidence is things like drafting history of the policy and industry custom and practice. Next bullet. You also need to look at what the allegations were in the underlying complaint. So an easier case may be where the plaintiffs allege breach of fiduciary duty for failing to maximize shareholder value. A tougher case might be where the allegations relate to a lack of disclosure of the board of directors. But ultimately, even the allegations are probably not going to be the most important thing you need to look at. Next bullet. Even more important is what did the settlement actually say and what did the payment made actually represent? So even if you have a lawsuit alleging that the board of directors breached their fiduciary duties by failing to fully disclose material aspects of a transaction, the settlement may very well have been for a sum certain to be distributed to shareholders on a per share basis. In other words, that the consideration received by the shareholders was bumped up. Next slide. Now, when interpreting a D&O policy, courts will focus on how the language addressing the bump up claim is worded. So is the language clear or is it ambiguous? Is the exclusion broad or narrow? Courts have found some policies define the universe of what isn't covered much more broadly than others, which may only exclude a very specific type of claim. Is the provision a carve back from loss or is it an exclusion? Some D&O policies have an exclusion for bump up claims. Others will carve back coverage for bump up claims from the definition of loss. And the thought here is that carriers generally have the burden to prove an exclusion applies, whereas a policyholder has the initial burden to prove its claim falls within the policy's definition of loss. I will say, though, while the burden of proof issue will depend on your specific situation and jurisdiction, courts have largely rejected carriers' attempts to make this distinction and require the carrier to demonstrate that a bump up claim is excluded under the particular D&O policy. So let's look at a few bump up provisions that have been the subject of litigation and how the parties and the court have interpreted them. Next slide. So the first bump up provision we're going to look at was an issue in a case called Genzyme versus Federal Insurance Company out of the Fifth Circuit in 2010. And this is one of the earliest cases dealing with a bump up claim. And you see the policy at issue had this bump up exclusion, provided that the insurer shall not be liable for that part of loss other than defense costs, which is based upon, arising from, or in consequence of the actual or proposed payment by any insured organization of allegedly inadequate or excessive consideration in connection with its purchase of securities issued by an insured organization. So just to give you some of the facts here, Genzyme was a biotech corporation and it set up its capital structure to include tracking stocks that were designed to track the performance of particular divisions rather than the company as a whole. And Genzyme invoked a provision in its articles of incorporation under which it was permitted to exchange tracking stocks for regular Genzyme stock. And the price was to be equal to 130% of the fair market value of the tracking stocks. The share exchange was unpopular and several class action lawsuits were filed. And the lawsuits included a number of allegations, including that the Ds and Os breached their fiduciary duties by undervaluing the price of the tracking stocks. Ultimately, the lawsuit settled for $64 million, all of which was paid by Genzyme, and the settlement was distributed to shareholders on a per share basis. That is, the more shares someone held, the more money that shareholder would receive. And so after paying the settlement, Genzyme went to its D&O carriers and sought the full limits of its policy. The policy again contained the bump up provision on the screen, which the carrier relied on to deny the claim. And the court here agreed with Federal and found the exclusion applied and precluded coverage. And first, the court noted that Genzyme had acquired tracking stocks effectively from itself, a capital I insured capital O organization. Second, the court noted that the consideration for the exchange was allegedly inadequate, leading Genzyme to make a payment, that is, a loss. And the court rejected Genzyme's argument that Genzyme did not actually purchase any securities, finding that an exchange of shares in the manner that it was completed would commonly be referred to as a purchase. And so under the facts presented, this exclusion was held to preclude coverage where an insured does what is effectively a stock buyback. Now, this provision is actually interesting in that it also may apply where there is allegedly excessive consideration paid by the insured. In other words, that the insured paid too much in the purchase of securities. And these types of overpayment exclusions are sometimes referred to as green mail exclusions. And the thought here is, at least the original thought, was where a corporate raider comes over to take over a company or a subsidiary in a hostile takeover, the company may have to overpay to regain control. And so carriers didn't want to cover the company for that overpayment. Next slide. So this is another bump up provision that was at issue in litigation. And so this is actually a carve back from loss rather than an exclusion. And so we see it provides that loss does not include any amount representing or substantially equivalent to an increase in consideration paid or proposed to be paid in connection with any purchase of securities or assets of a corporation or any plaintiff's counsel's fees in any claim alleging inadequate or unfair consideration. And this provision was at issue in Gardner, Denver, or GDI versus Arch Insurance Company. And so in GDI, you had Kohlberg, Kravis, and Roberts, or KKR, acquiring GDI in a going private transaction. And so GDI shareholders received a certain dollar amount per share, and GDI became a subsidiary of KKR. Following KKR's acquisition of GDI, several class action lawsuits were filed against GDI's board of directors, alleging they breached their fiduciary duties by undervaluing GDI in the sale to KKR. In other words, the shareholders complained that they did not receive enough money for their shares in the transaction. Ultimately, the lawsuits were settled for $30 million, GDI paying that amount, and the amount was distributed to shareholders on a per share basis. And again, as is often the case, GDI thereafter sought coverage for the settlement from its D&O insurers. And here's the D&O provision that was at issue. And so here's the quick facts. GDI's stock is acquired by KKR. GDI was sued by its shareholders, saying GDI didn't get enough money for their shares. GDI pays $30 million to settle those suits, and the $30 million was distributed to shareholders on a per share basis. So let's look at how the parties and the court looked at it. The carriers argued the language was unambiguous and that GDI's claim was not covered. The carriers relied on the language of the policy, and since GDI's $30 million payment represented an increase in consideration paid in connection with the purchase of a capital C corporation's securities, the loss was not covered. And the policy defined corporation as GDI. GDI, not surprisingly, had a different take. It argued that the loss carveback only applied where GDI purchased the securities of a third party, not where GDI was itself acquired. And the way GDI got there, in light of the defined term corporation, which again was defined to be GDI, was pretty creative. So it relied on the word a before corporation. And it noted that because other place in the policy referred to the corporation when talking about GDI, a corporation had to mean something different. GDI also argued that the custom and practice of the D&O industry would be that the bump up provision would only apply to the insured's acquisitions of third parties. And this argument being that D&O carriers didn't want to subsidize an insured's acquisition of another company, as doing so would incentivize Ds and Os to lowball their offers to acquire other companies, knowing if they were sued, an insurer would pick up the tab. Of course, the flip side to this argument is that an acquiring company's Ds and Os don't really have a fiduciary duty to the shareholders of the company to be acquired to pay a fair price. In reality, the acquirer's Ds and Os have a fiduciary duty to their own shareholders to pay as little as possible for the acquisition. In any event, the carriers filed a motion to dismiss GDI's complaint, arguing that the loss carveback unambiguously precluded coverage for GDI's claims. And here the court ruled, for purposes of the motion to dismiss, that the language was ambiguous and it denied the motion. The court noted that viewing the facts in the light most favorable to the plaintiff, a reasonable person could construe the use of the phrase a corporation as meaning an entity other than GDI. Notably, the court did not address the fact that even if you interpret a corporation as not referring exclusively to GDI, GDI was in fact a corporation. It's also important to note that the court did not conclusively rule the policy language was ambiguous, It only did so for purposes of the motion to dismiss, which requires a court to view the facts alleged by the plaintiff in the most reasonable light. Next slide. So here's the next bump up provision that we're going to look at, and it was at issue in Onyx Pharmaceuticals versus Old Republic. This is a California Superior Court case from 2018, so pretty recent. And here you find the bump up provision provides in the event of a claim alleging that the price or consideration paid or proposed to be paid for the acquisition or completion of the acquisition of all or substantially all of the ownership interest in or assets of an entity is inadequate. Loss with respect to such claims shall not include any amount of any judgment or settlement representing the amount by which such price or consideration is effectively increased. And so in Onyx, we had Amgen Incorporated acquiring Onyx in an all-cash transaction, whereby Onyx shareholders recovered $125 per share. The plaintiffs, which were Onyx's shareholders, sued Onyx and its board of directors for breach of fiduciary duties, alleging they failed to maximize the price to be paid to Onyx's shareholders. The lawsuit was settled for $30 million, which was distributed to shareholders on a per-share basis. Onyx thereafter sought coverage for the payment under its D&O policy, which again contained the provision on the screen. And like the language in GDI, this is a carve back from loss rather than an exclusion. And the language carves back loss with respect to payments made for claims alleging that the price paid for the acquisition of the assets of an entity is inadequate. So in Onyx, we have Onyx being acquired by Amgen, Onyx being sued by its shareholders for failing to maximize the amount paid to shareholders. And we have a settlement under which Onyx agreed to pay its former shareholders $30 million, which was distributed on a per share basis. So is Onyx's claim covered? Carriers argued no. Onyx is an entity that was acquired, and the settlement represented an increase in the amount of consideration for the sale. Onyx argued the opposite. The claim was covered and that Onyx did not fall within the term an entity. And to support its argument, Onyx noted that throughout the policy, where the policy meant to refer to Onyx, it would use the term named entity, which was defined as Onyx. And therefore, by using the term any entity rather than named entity, the policy couldn't have been referring to Onyx. Ultimately, the court found in favor of the carrier and held that the loss carveback did have the effect of excluding coverage for Onyx's claim. In other words, that the provision precluded coverage since an entity, which was Onyx, was acquired, and the settlement represented an increase in the amount of consideration for the sale. Next slide. And so the last provision, one back, we're going to look at is very similar to the one we just looked at. So I'm not going to read it again, but this was at issue in an even more recent case just this year, Northrop Grumman versus Zurich. And interestingly, even though the provisions are almost identical, the court reached the opposite result in this case. So just the quick facts. In Northrop, you had Alliant Tech Systems and Orbitable Sciences completing a reverse triangular stock-for-stock merger, out of which a company, OATK, was born. The merger followed disclosures to stockholders and a proxy vote. But after the transaction was effected, lawsuits were brought by the former Orbital Sciences shareholders against OATK and certain directors of the former Alliant, alleging that the proxy solicitation materials contained false or misleading statements. In other words, that the vote to approve the transaction was based on false pretenses, since the value of Alliant was misrepresented. And the shareholders sought over $100 million in damages. OATK, it actually settled for over $100 million. OATK, which had been purchased by Northrop in the interim, thereafter sought coverage for the settlement from its carriers. And the carriers again denied for a lot of reasons, but one because of the bump up provision on the screen. Here, unlike in the Onyx case, the court sided with the policyholder and found that this provision did not exclude coverage. And it did so for some interesting reasons. So first, the court found that the bump up provision, even though phrased as a carve back from loss, was in fact an exclusion, and therefore had to be interpreted very narrowly. Second, the court held that the claims made by the shareholders were not exclusively about inadequate consideration, but also involved dissemination of a materially false and misleading proxy statement. Third, the court found that the bump up provision, by its own terms, only applied to the acquisition of another company. That is, where both companies retain their legal existence after the transaction. And that because the transaction at issue was a merger, the bump up provision did not apply. And lastly, and at least to me, what was most important, the court found that the settlement did not represent an increase in the consideration paid to the shareholders. Rather, the court found that the settlement was to compensate the shareholders for the harm caused by the overvaluing of Allianz. In other words, that Orbital gave up too much in the merger with Allianz. And therefore, the settlement actually represented a bump down, not a bump up. And so at first blush, it may seem that the Onyx Court and the Northrop Court reached conflicting conclusions regarding the application of what was largely an identical bump up provision. But the Northrop Court actually did not disagree with Onyx, and it rather just distinguished it. And the court noted that in Onyx, there was an acquisition, not a merger. And it also noted that in Onyx, the complaints by shareholders were that their stock was undervalued or sold for less than it's worth, unlike in Northrop, where the court found the complaint was the overvaluing of the stock. And lastly, the court noted that the settlement in Onyx effectively increased the consideration for that stock, unlike in Northrop, where the court found the settlement effectively bumped down the overpayment. Next slide. So when courts are trying to interpret these bump up provisions, which can be pretty complicated, a court's goal, just like when interpreting any other contract, is to effectuate the intent of the parties based on the language of the contract. And so where the language is clear and unambiguous, the court will interpret the policy without resorting to extrinsic evidence. But as we saw in some of the cases we just discussed, even what may appear to be clear language may be susceptible to an argument of ambiguity. We saw, for example, arguments made that the words "an entity" or "a corporation" were both ambiguous. And not surprisingly, ambiguity is often in the eye of the beholder. So while I may see a duck, many will see a rabbit. And if a policy is found to be ambiguous, the court will then consider extrinsic evidence to assist in the interpretation of the policy. Next slide. And so the extrinsic evidence a court will consider in any given case can vary greatly and will largely depend on the particular jurisdiction and even the particular judge. But in almost every case, you're going to have the underwriting or negotiation of the policy at issue be very important. And this is going to include discussions with the insured, discussions with the broker regarding the policy. And obviously, if there's particular discussion of the bump up provision, that's going to be critical to the court in determining what the intent of the provision was. The court may also consider industry custom and practice. How does the industry view this bump up provision and what was it intended to do? Usually this is going to be in the form of expert opinions, which will often simply lead to each side appointing an expert who provide directly opposing views on the given issue. And then ultimately it's up to the court to decide which expert is the most credible. And again, when reviewing all of this extrinsic evidence, the court's goal is to determine what was the intent of the parties. Next slide. With that, I'll quickly pass it back to David just to address the first takeaway here.
Sorry about that. The first takeaway is an easy one. Litigation objecting to mergers and acquisitions is not going anywhere. As we saw before, deal volume is down. but largely due to COVID. But in any case, the litigation continues, and we can expect that shareholders will continue to contest mergers and acquisitions of large public companies where they allege either the disclosures were inadequate or where the terms of the deal themselves were skewed or the sale process was materially flawed. Justin?
Go to the next bullet. And so, not to beat a dead horse, as I talked about it a lot, but obviously the specific language used in your D&O policy, and if you're dealing with a bump up claim, the language used in your bump up provision is absolutely critical. As we saw, small differences like whether the provision only uses the word acquisition as opposed to a merger, or whether the provision applies to the acquisition of a capital C corporation or the purchase of an entity, may determine whether a given claim is covered or excluded by the policy. And again, if you want to avoid the use of extrinsic evidence, you need to be certain that your bump up provision is clear and unambiguous. And next slide. And with that, David and I are happy to address any questions anyone has. Thank you.
Thank you.
Great job. Thanks so much, guys. I'm going to edit the video in preparation for the 27th. I'm going to, on the 27th, I'm going to announce the last slide with the CLE and do the thank you at the end, so that I can fill in the questions so that we can allow people to have time for questions and everything at the end. But I'm going to edit this part out just to have the presentation.
Sure.
But great job. And if you guys have any questions, or if you concerns or anything like that, we can definitely, we have time. We have about 2 weeks before the presentation. But I think this was a great run. I think this was a just a great job. And like I said, once I edit everything, I can see if anything is needed. But as far as we hit it right on the 60-minute mark.
I was nervous.
Yeah, me too.
Yeah, all of
we
us.
hit it
Yeah,
right on the 60
I
minutes.
had highlighted some stuff that I could skip. I thought, like, if it seemed like we were running short, so I was happy I did that because I skipped that stuff. And
I went quickly through the last few slides. My part, but it was fine because everything that I can think of only one thing that I forgot to mention, but it's not not important. So
and here's the thing, we can always go back because like I have it set now on the 27th for an hour and a half. So like with the questions and everything, you can always go back and kind of address those different things.
Exactly.
So,
Right. That's I'm hoping someone will ask some questions, and that would be good.
Well, and if not, you could just continue on, kind of takeaways and everything. But
Okay.
We should be good to go. I really think that it was good.
all right.
Good.
David, do you want to just stay
Taja.
on so we can chat?
Yeah, can we do that, or you're controlling
as long as Taja
us,
makes
right?
one of us the host, we should be good.
Okay, yeah, make Justin the host if you would. Thank you, Taja, so much.
Thank you.
You're welcome. You're welcome. And Justin, I'll make you the host. And like I said, I sent you guys the RSVP. If you have any questions or anything or concerns, just let me know. Feel free, and we can go from there.
I saw we're up to over 50 now too. So
yeah.
What you think? I'm sorry.
We're up to over 50 attendees.
Exactly. Yeah. Well, I think it's because I added that line with the approved for CLE. I don't know if you saw that.
That'll do it.
Never heard.
That'll do it. Do it. And so what we'll do is we'll attend the entire session, right? So we'll kind of be there watching it. And then at the end, we'll go live with the questions.
Just jump in.
Okay. Got it.
Correct.
Got it. Great. Okay. Good.
All right. Thanks, guys. Have a great day.
Thanks, Taja. Hey, you too.
All right.
Bye.
All right.
Okay. So I was a little bit nervous about the time, but we did it. So that's good. That's good.
I was too. Yeah.
So Barry really basically cut it in half.
Yeah, I was surprised. I
Wow.
mean, I don't know what took him so long, but yeah.
I guess they decided they really didn't want to argue for some Outlook appointment or